Hi, everyone. Welcome to the Danielson Group webinar series. For those of you that don't know me, I'm Ray Glicksohn. I'm one of the partners here at Danielson Group, and I will be our host today. Before we get started, I have a couple of housekeeping items that I need to share with everybody. So the first is that this session is being recorded, which means you don't have to take detailed notes right now. We're going to send a follow-up to everybody in attendance, of which I think we've got in excess of 50 or 60 people already joining us, which is kind of cool. This is a Zoom session, and while we know how many people are on, you're only going to be able to see me and hear me and our guest, Mary. We cannot see you and we cannot hear you. So if you're having a party in the background of wherever you're at, we can't hear that. Today's session was created as an educational session, definitely not to be construed as advice for estate planning. The idea really is to help you figure out some of the questions you should be asking your advisors, which is probably one of my partners here. Estate planning is an enormous topic. We probably could have a weekly webinar with Mary and for a whole year and not cover all the topics. So we picked, or based on your feedback, these are the three top areas that we think are important to you. And so we're going to sort of spend probably 12 to 15 minutes on each of these areas. And last is, we want to keep this to an hour. Okay, so we'll be respectful of your time. Given that it's only an hour, we've actually turned off the chat feature, so we're not going to be taking questions during this time. If you do end up having questions, reach out to any one of us, and we'll definitely do our best to come up with those answers. All right, so without any more ado, I think now's a great opportunity to introduce our guest speaker. It's Mary Hamilton. Oh, here's Mary. Mary is a partner at she's a lawyer, first of all, and a partner at Alexander Holburn. I've had the pleasure of working with her, with our clients, for the past at least decade of having Mary create great estate plans. The reason why we selected Mary out of the various lawyers that we work with is because she has this one skill set which I value almost above all others, and that she's able to take complex concepts and put them into lay terms so that virtually anybody can understand what it is that needs to happen. One of the great things, well, any advisor who is good at what they do always starts with questions. And Mary is brilliant at asking those questions, listening to find out what is the actual issue that you're facing, and then coming up with solutions. Now, of course, during this session, she's not going to be able to ask those questions of anybody. So we're going to probably use me as a bit of a guinea pig and hopefully try and have some scenarios that we've seen with our clients. I'm not going to pretend that everything that we talk about today is exactly accurate, but it should hopefully give us a foundation of somewhere to start from. Before I hand over and start that question process, I do have to point out that Mary really is quite incredible at what she does. And she has actually been named Vancouver Trust and Estate Lawyer of the Year by the Best Lawyers in Canada in 2011, again in 2017, and to not be outdone, she's already been named with that honor for 2021. So Mary, thank you for joining us. We're super excited for this session, and great to have you on our webcast.
You're very welcome. Thank you for inviting me.
Okay, great. So people aren't here to hear me, they want to hear from you. So let's just jump right into the very first topic, which is one that it doesn't impact everyone, but the people it does impact, they all want to know. I have a recreational property. How do I deal with this recreational property? And I think we had kind of said that we could use me as a guinea pig. So you know that I have a property in Naramata. How about we sort of maybe jump back and forth a little bit? You can ask me some questions and get into how to deal with that.
Sure, because one of the challenges is most people want their recreational property to pass down the generations. So how can I leave this? My wife and I want to leave it to our kids and ultimately grandkids and the like. And the first is actually, do your kids get along? Because leaving property to a number of kids who actually don't get along or whose spouses don't get along can be fraught with danger. You might want it to work, but that doesn't mean it will work. But assuming you think that that will work, some people actually do a co-ownership agreement and make a deal ahead of time as to how this property is going to be used. I know your daughters are younger and they don't yet have spouses, and you're probably not at that stage. But there's different ways to do it. You can just leave your property in your will. That leaves you lots of flexibility to wait and see how things evolve during the course of your lifetime, your daughter's lifetime. Does this make sense 10 years from now? It may make a lot of sense today, but not in 20 years. When you die, or when you and your wife both die, there will be tax on the capital gains. So you've got a plan for that. Be able to pay the tax, and then you can leave it outright to the girls. You could leave it in a trust for the girls in your will. But some people want to do something ahead of time, have that plan in place already. So you could put it in a trust right now. You would trigger your capital gains now, though. So you'd have to be ready to pay the tax on your capital gains now when you put it in. The good thing about doing that is you've now got a structure. Everybody knows going forward it's in a trust, who the trustees are, who the replacement trustees are. There's nothing that has to happen on your death because we've already got it in place. One of the drawbacks, it's always income tax. Trusts are only good tax-wise for 21 years. And in 21 years, the trustees will either, just before 21 years, pay that property out to your daughters or one of them or whatever, or pay the tax on the capital gains at that point and keep going. You're not 65 yet. Otherwise, we would maybe think about putting it in a joint spousal trust and alter ego trust. We're going to, I think, try and talk a little bit about those in a minute, so I won't go into that. So leave it in your will, put it in a trust. You could put their names on it right now. Some parents or grandparents say, let's just put the kids on now.
Are there tax consequences if we do that?
You would trigger tax. If you and your wife put 2 daughters on, you'd trigger half your capital gains because you're transferring half the property, a quarter to each daughter. But maybe transferring half and paying tax now isn't a crazy idea if it hasn't gone way up in value. And then there's no tax on their piece when you die. They already own it. The challenge is your daughters own part of your property. You know, what if you don't get along? What if there's a falling out? What if you guys decide you want to sell it and the girls go, no, we love the property, but you want to be able to travel or pay for nursing care or something else. So that's a problem. Or what if they go through a relationship breakdown? Now you've got the ex-spouse claiming a piece of your vacation property or wanting full disclosure of all that information. What if they get sued? What if they, they're in a profession where they get sued, they didn't have insurance, there's a creditor wants $1 million and your daughter doesn't have a lot other than a quarter interest in the property in Naramata. So, you have to be aware of those issues if you're going to start putting property right in their name today. Some people do put it in a company. That's complicated tax-wise. There may be a shareholder benefit for people using the property, but that's also possible. I did one of those just before Christmas. We transferred interest to a company for some property on the island. So getting advice on maybe that. The nice thing about companies is they don't die. They keep going, right? And then you just have the shares of the company that transfer.
Is there anything that we could do today that doesn't trigger tax?
The nice thing about the alter ego trust, if you were old enough, you could put it in a trust. You could do a freeze of the property. It gets a bit complicated. You could keep the present value of your property and put the future value in a trust or in the girls' names. And for some properties of significant value, that would be worth doing. It gets expensive legal fee wise and accounting wise, but yeah, some properties are well worth considering that for sure.
Okay, is there anything else around recreational properties? I know we probably don't want to go too far down this rabbit hole, but if I know that you have a property that's not in Canada, is that something worth maybe touching?
Yeah, just so we have a property in Point Roberts, 30 minutes from here that, as the listeners will know, we can't get to because it's across the line in the US. Property in the US, totally different situation. Absolutely. And if you have people in your life who are Americans, so if your nieces and nephews who may be beneficiaries of the trust holding the property are Americans, that may be an issue. Or if your daughter is residing in the US, she's going to school down there and her partner is an American, those are all issues to worry about. And quite frankly, the recreational property, the family cottage, it's mostly about use. Where we see parents want equal, but down the road, the kids aren't using it equally, right? One daughter's living in New York, the other daughter's living in Penticton, using Naramata all the time. So are we equally sharing expenses? You know, the one daughter says, you know, I don't want to pay half the expenses. Are you going to set aside a fund to fund the expenses in your trust, in your will, separate pot of money? Or are you going to say to the girls, so their expectations are at the right place? This is what we're going to do. You guys are going to inherit from us. We think you should each set aside a fund to pay the taxes, to put the new dock in, to put a roof on the place. Usually it's the upkeep of the property. The people using it all the time, wanting it at a certain standard. The people using it 2 weeks in the middle of the summer, they don't care if there's, you know, heat. It doesn't matter to them. Yeah. So we do co-ownership agreements, who gets which weeks, who gets which, you know, months, holidays, those sorts of things, and that helps. Not so much your next generation, it's the following one. It's when all the grandkids are the owners. And they're all cousins. They don't know each other as well, and they all have spouses, and that's when it gets complicated. So we certainly have properties in the fourth generation, but careful planning to keep that working.
Okay, so I think that's a pretty good high level things that people need to think about. Okay, maybe we can move on to that next topic, which you had alluded to already, which is owning it jointly. Right. And maybe we could talk about that specifically with this property, but I think there's also other types of property investments we may want to look at owning jointly. So I'll let you sort of dive into that.
Absolutely right. We get questions every day about joint ownership, and it's keeping our litigators in business when people die. Because, you know, did you put that account or that property in joint ownership with the intention, say you put it just in joint names with one daughter, was the intention that that daughter would take it and hold it for the family, or is it hers? And we see it mostly with investment accounts or bank accounts. Is the intention that it's a true joint tenancy? So if my mother names me on her bank account, when mom dies, it's all mine, and I can do whatever I want with it. That's how spouses typically have joint accounts. But what about when it's parent-child? Particularly if I'm the caregiver, I might think that I should get all that because my siblings haven't stepped up at all, thank you very much. And I somehow start to feel really justified in keeping that. But there is a kind of joint account where the intention of mom is just, it's for convenience. It's just to pay the bills. And it's really mom's account when she dies. And I hold it for her estate. It's still part of her estate. There's still probate fees. The great thing about joint accounts is people are trying to avoid probate fees. Right. Keeping it in perspective, they're 1.4%. They're not worth reorganizing your life over necessarily. Okay. It's 14,000 on $1 million, but it's 14,000 on $1 million. Now, if all you've got is $1 million piece of real estate and no cash, that's a problem. But I do like people to keep it in perspective. It's not like US estate tax, which is 40%. It's 1.4%. But we don't want to pay probate if we don't have to. And if that's more money, that can end up with our families or with charity. So put it in joint names. So when mom put my name on the account, am I supposed to hold it for her estate? In which case it still counts for probate. Or do I get to keep it? Or am I supposed to keep it and use it for all the siblings? And are we just kind of skirting around the will and I'm supposed to still divide it among the 3 siblings? The challenge is for the court, the intention of mom is what's important. And every single time mom's died. So my perspective is different than my sister's perspective, or maybe than a creditor of my mom who is looking to be paid. So what we urge clients to do is figure out what you really mean when you put assets in joint names and then document that. I actually do a deed of gift that says I am putting my account in joint names with my daughter, and the intention is holding it for me, she gets to keep it, whatever that is. That deed of gift and maybe even a deed of trust is going to be helpful. We see people's views change over mom's lifetime, and that's what's hard to predict. And the court wants to know what mom's intention was when she set up the account, not what her intention was on her deathbed.
Okay.
And the courts have said it's fine and dandy that you tick the little box on the bank form that said joint tenancy with right of survivorship. That's one of the, but did mom really know? And did she get the proper advice from the bank teller when she opened the account? And what's happened is a lot of our banking personnel are becoming estate planners. They're saying, oh, you should just put it in a joint account. That'll be easier. Yes.
Wow. So
maybe.
We talked about for my property. So let's maybe flip it around. So my mother's in her 70s. She's not admitting that right now, which is great because that makes me younger too, I guess. But she has an investment portfolio, and there's some capital gains on this portfolio. If she puts that in joint name with me, can you walk us through what that means from a tax perspective? And is it the same as what you just talked about with the savings account?
Yes. If it's a true joint tenancy and she's really giving half of that account to Ray today, and you will hold those jointly, and it's with right of survivorship, which just means the survivor takes all. So if Ray dies, it's back to mom's name. If mom dies, it's all Ray's. There's a deemed disposition of half of the account. She's giving away half to Ray today. If it's going to a spouse, there's no tax, but if it's going to a child, that would trigger any capital gains on half of the portfolio. If it's going into names with 2 kids, now 2/3 of the portfolio, right? One of the questions is going forward, who pays the tax on the income? If the investments are doing very well and you're earning going forward and there's capital gains, is Ray paying tax on half? And in retrospect, that's what we look at after mom's gone. Mm-hmm. And there's a question about whether it was really to be Ray's account. We look, well, Ray, did you declare any income on that account for the past 20 years? And usually the answer is no. Usually all of that income went on mom's account. That may not be fatal. There's the Supreme Court of Canada kind of invented a new kind of joint account, and it's joint in name, but it's mom's alone during her lifetime. And all mom is giving you is the right of survivorship. So mom's account, that's why you need to document it, because how do you know this stuff, right?
Right.
Mom's account, you don't have to pay any tax on the income. It doesn't trigger any tax when mom sets up the account because she's not disposing of anything. But when mom dies, that comes automatically to you outside of the estate, no probate. And really importantly, no opportunity for your black sheep brother to bring a claim on mom's estate and say, actually, I think I should have half of that account. because in BC, we let any spouse, doesn't matter if you're married a week or 60 years, any spouse and any child, however old you are, we let you bring a claim against an estate if you don't think you're fairly done by. So that account that went to Ray, and we didn't trigger any tax because we used one of these cool, Supreme Court of Canada invented accounts, went to you and we documented it, then the black sheep brother can't come along and bring a claim. So yay, we avoided probate, but even better. And so we see that a lot in blended families, right? Because classic case is second spouse and the kids from the first marriage. Right?
Yep.
And whatever mom or dad does, it's not necessarily going to be seen as fair by all involved.
Okay, so in order, if someone wants to go down that route to use that, what's the process of doing that?
So I would talk to a lawyer. The kind of account, it's called a PECOR, P-E-C-O-R-E. That's the name of the case. That's sort of the shorthand that we lawyers use. And you'd want mom to document, I'm putting my investment account in joint names. It's mine during my lifetime. And on my death, it goes by right of survivorship, not through my estate, not through my will, but by right of survivorship to my favorite son, Ray.
Okay, well, that sounds good for me. Now, does that need to be witnessed? Like who prepares that document, and how do you do that so that it's done right, so that it doesn't get challenged?
Which is why I would say get legal advice, right? That's why you get lawyers to look at things, because mom's gone when we're in this mess and you and your nefarious brother are battling it out. And you're saying, well, mom intended. And if there's a piece of paper, but there's no witness, who drew this? Did mom even understand what she was signing? Mom kind of lost it after a while and nobody kind of remembers how she was on January 27th, 2021. So the lawyer's notes will say, I met with mom. I explained all of this. Right. Mom wanted to do this. And so when I witness that and I keep my notes, that makes the document more robust and is more likely to stand up.
Okay. All right. So we've covered wreck properties. We've covered joint. What are our other options? And go for it.
Good question, because I mentioned earlier on alter ego trust. I said you weren't 65 yet. 65 is a magic day for those of us in estate planning. I recommend everybody circle that on your calendar. For those of our listeners who've made it that far, you may have already done this, but 20 plus years ago, the government of Canada just gave us a gift, and they said, if you transfer your assets to a trust, remember I said it triggers your capital gain?
Yeah. Unless
it's an alter ego trust. Joint spousal trust if there's a couple, or joint partner trust, common law partners, spouses. So alter ego for one person, joint partner or joint spousal trust for a couple. You have to be Canadian residents. There's a few rules, and the person setting it up. So if I were 65 and I set one of these up, I have to get all the income during my lifetime. And nobody else can get any capital. It's mine during my lifetime, but it's a separate trust. And CRA said, and we're not going to trigger any capital gains going in. So the reason they did that is it's still taxed on my death. I may have mentioned trusts are typically taxed every 21 years. Yeah. But these trusts are taxed when the person who set it up dies, or the spouse if it's a joint one, and then the 21 years starts running. So if I transfer assets to that trust, I've now got them out of my estate, no probate fees, no probate on those assets, and I've avoided a claim to vary the will on those assets. So your bad brother can't challenge mom's alter ego trust.
Can just maybe explain why that is?
So the assets go through the trust on death. So if I've set up that trust, when I die, those assets go through the trust. They are nothing to do with my estate. They don't go through my will.
Okay.
So if I've got, good son, bad son can bring a claim on my estate, but he can't get at what's in the trust. The court might actually give him all of what's in my estate because of what the other person got through the trust, but they can't take anything out of the trust. So we do lots of these, just particularly blended families, worried spouse and kids are going to fight, or you've got kids that aren't going to inherit equally. Maybe you've got family business and one of them's going to get the family business and the others are going to get something else and they may not be happy about it. But it gives testamentary freedom in a sense. It's not a testamentary document, but it lets you do what you want in your will. A lot of people have been frustrated about the wills variation legislation in BC for a very long time. It was set up initially, it made lots of sense. I'm going to say early 1900s, the Destitute Widows and Orphans Act. So dad couldn't leave everything to the mistress and cut out the wife and kids. The government said, that's not fair. Wife and kids, you should be able to challenge the will and you should get something. Fast forward 2021, any spouse can challenge, any child can challenge, and particularly black sheep kids who have not been involved at all. Yeah. And that's frustrating to our clients. They want to be able to say where their hard-earned assets go when they die. So one way to do that is to say, set it aside in a trust. We don't want to trigger a bunch of tax going in. So we're just going to set it aside and we're then going to have those assets pass through the trust. Tax on death, but outside the estate.
So we talked about the recreational property. What are sort of other assets that we might want to put in there?
Well, I'm going to go back to rec property. The challenge with putting any land in is property transfer tax. Right? It's like a matrix with too many variables, and we can't land on the right answer every time. The property transfer tax applies whenever you transfer property and register that transfer in the land registry in BC, in the land title office. So some people will transfer to a trust and not register it. And that might work. We would want to document that and make it very clear that it was transferred in 2021 because it's still in my name when I die down the road, but the value is zero because I transferred it back in 2021 to the trust. It's not as clean as we would like. We used to be able to do, I used to call it a bit of a dipsy doodle with the principal residence and transfer it to spouse, to trust and back in. Doing that doesn't really work anymore. And there are concerns that our government is looking to capture tax on transfers, and they might change the rules. Right now, you still don't have to pay tax if you don't register that transfer, or you might just decide I'm going to pay that transfer tax. I want it clean and I want it on title, and my property, my recreational property is not that expensive. And maybe I'm going to do it before I build the fancy house on it while it's bare land. Even better, do it before you buy the house. Maybe if you're thinking of changing houses, and some people are downsizing from their big house. So sell your house in your own name, put that money in the trust, your brand new trust, and have your new trust buy your next property.
Okay, so if I'm hearing what you just said correctly, if let's say my mother has a home and she's 75, and maybe if we set up this trust now, we could put her investments in there, but we might not put her house in right away. And when she decides to downsize, when she would sell, and at that time she would have roll, like the new home would be purchased inside the trust.
That's right.
Okay.
That's right.
And
if mom's got good planning advice, she's probably going to contemplate some of that when she does her power of attorney. Because if mom's doing a power of attorney and then loses capacity, so you're now her attorney, you're selling the big house, you might like to buy the small condo she's going to live in with the caregiver? And can you put that money in the trust? I would want to see that power right in the power of attorney, because you're technically moving her assets into a trust, which is out of her name. Yep. And so you can do that, but we try to contemplate that right in the power of attorney.
Okay, and I think a lot of people would want to also know, if you put your principal residence into this trust, does it still qualify for the principal residence exemption?
Yes, and that's why alter ego and joint partner, joint spousal trusts are so important, because it used to be any old trust would qualify for principal residence exemption. And in 2017, they really narrowed those rules, and they've made that quite complicated. But the exception is alter ego trust, joint partner trust still qualify.
Fabulous.
So you'll get your principal residence exemption, trigger tax on death, but it'll be exempt if it's your principal residence.
Okay, so ideally, you kind of want to maybe set this up around the time that you might be downsizing, or be super mindful that when you do downsize, whatever is next, to run it through the trust, and that's the cleanest way to do it.
Or if you really want to do it now, you do the bare trust, but again, with a view to cleaning that up if you downsize or have time to downsize, right? Some of us die before we get that far, but yes. And so it depends how important it is that you actually get that into the trust.
Okay.
Okay.
What else about these trusts should we be thinking about?
Well, that's very, very good to bring up other issues, because trusts are complicated.
Right.
It's for those listeners that have their own company, we're bringing in another entity, kind of like your own company. You've got to file a tax return every year. You've got to do trustee resolutions if you want to move assets in and out. You've got to open separate accounts. You guys are in the financial industry. You know, opening accounts is a bit of a big deal with all your know your client forms. Every bank has different rules for opening accounts for trusts. And the rule I mentioned is all the income has to go during your lifetime to the person who set the trust up. So you've got to track, the $30 that was earned has to go to that person. And are you doing that daily? Is that an annual resolution? Different people have different approaches. But absolutely, you've got to track that. You've got to file the tax return. And now, and I caution people about this, there's a lot of disclosure about beneficiaries of trusts. So if your trust looks a lot like your will, and it says it goes to my 2 daughters when I die equally, and if they don't survive me, it goes to their kids. But if we're all gone, it goes to all of our nieces and nephews. The challenge is all of those nieces and nephews are beneficiaries of this trust. They're contingent beneficiaries. They're probably not going to get anything. But even if just one of them is a US citizen or not a Canadian citizen, this is just silly, but every time the trustees change and you change on title to your property, you pay an extra 20% tax. It's crazy.
Wow.
There's this extra additional property transfer tax that applies every time you change trustees. And so we have to be careful when we're setting that up. Are we going to have a whole bunch of potential beneficiaries? Or are we going to narrow that down a bit? And so, yeah, there's other issues managing that trust. What is great though, is if you become, it's not great that you become incapable, but if you become incapable and you have an alter ego trust, we just carry on business as usual. Your attorney doesn't have to get involved to manage anything, because your trust will say the alternate trustees are, or you already have other trustees in place, and they just continue to manage the portfolio, manage the property, whatever it is. While I think of it, Ray, so probate fee savings, wills variation, avoidance, potentially. I didn't mention privacy, but privacy is important for a lot of people. Anyone who's been through the probate process knows that it's public. a list of all of your assets and their value at the date of death get filed in the probate registry, and anyone can go look. So you can go look up, what did your neighbor leave in his will when he died? And some of our clients are uncomfortable with that. Either, maybe they're a name that's known, but maybe it's that bad daughter-in-law or her family that you're just worried they're going to charge in there and see how much old Ray left when he died, and it gets uncomfortable. So a lot of people like that privacy. So there's a cost to it, administering your trust, setting your trust up.
One of the things we haven't really talked about yet in any of these examples is after the death, what's the timeline and what does that look like?
So if you leave assets in your will, the estate is going to have to be probated. Probate is just proof that that's the last will. It's just a sort of mechanical process in the probate registry, but it involves listing all your assets. There's a rule of law that says the estate can't be distributed for 210 days after the grant of probate without the consent of everyone. And if you have those trusts with everyone and their dog in there, then it's going to be 210 days after probate. Probate registry right now is 8 weeks behind. So it's going to take you a couple months to file for probate, and then it's going to take a couple months to get probate, and then you're going to wait another 7 months for a grant. You're not distributing those assets for at least a year.
Right.
You may want a clearance certificate from CRA. That's another 6 months to 8 months to a year or more. The trust, if your assets were in the alter ego trust, when you die, the trustees are going to want to make sure the taxes get paid, and then they can distribute. There's no restrictions at all.
So that literally could be weeks or months?
Yeah, particularly if the trustee is the person you're distributing to, they can just do it, quickly.
Wow. And when they do that distribution, do they distribute to the person individually, or does the trust continue in some capacity?
Depends how you set it up. So if you're setting it up for your 2 daughters, you may say they get it outright, or you may say, no one that young should inherit anything really, and we're going to hold it in a trust. My thing is, 25 is the new 19. I don't give anything to anybody until they're at least 25. People just don't make great decisions. Yeah. And maybe it's 30, maybe it's 35, maybe it's staged out. So it is a continuation of the trust or a sub-trust, or it doesn't have to be outright.
Okay. Wow. Okay. So there's a lot to consider when it comes to these. You have to be 65. Can we just circle back on the US? If anybody is a US citizen?
Big red flag. You need to think that through. If your trustees are US, if the property is in the US, mm-hmm. or if the beneficiaries, any of the beneficiaries are US or another country.
So when you're talking property, individual stocks that are US stocks, would that be considered US property? That's
a good question, because it may be, for Canadian purposes, we treat US stock one way, but the US looks through trusts for estate tax. So I'm not sure how that would all work out. I'd have to look at specific examples and then call someone who does tax law. But those are red flags. You need advice.
Okay. So again, if spouses, you're looking at a joint spousal trust, if one is a US citizen, very unlikely that we would go down that route.
Yes.
Okay.
Yeah. Anytime I have US people, I always get advice. There aren't very many people actually that do the US piece. Mm-hmm. People will get advice from the US lawyers, and unfortunately, a lot of them tend to presume that Canadian law is the same as the US law and recommend things that just don't work up here, or things like joint tenancy don't work very well down there. They tend to tax when the first one dies and then again when the second one dies.
Wow. Okay.
So they're different regimes, and you need someone that can talk both languages.
Yeah. Okay. So I don't think we want to go down the U.S. Citizen rabbit hole too far.
And I don't know enough to do that.
Sure, you bet. Okay, one of the fun topics that's actually come up a little bit lately is around people with pets, and there's people are very passionate about their pets. Should pets somehow be included in a will?
Well, I said, everyone and their dog was a beneficiary. And I actually said that somewhat advisedly because people are worried about their pets. Pets are the new children for some people, right? And they want them cared for. So at law, pets are still property. You don't name a guardian for your pet. You name a new owner for your pet. But some people want to do that. They want to give the pet to someone and maybe give them money to go with the pet. And that's the challenge, right? Pets are expensive, and some pets particularly, there's the grooming, there's the dog walker, there's the vet bills, there's the special food, they're expensive. And if you want to leave the pet to someone who doesn't have a lot of resources, you're going to want to leave money. So how do you do that? Do you often it's just, trusting them. I'm going to give them $10,000. If the dog dies the next day, they got a windfall. If the dog lives to be 18, they're probably in their own money by then. And we just pick a number that the client is comfortable with. I have set up trusts for pets. I have put money in a trust and it is meted out for the benefit of the pet. There's a 21-year cap on trusts for animals. So I had one woman, she had parrots. They lived for 80 years. Yeah. So we actually had to work around the 21-year rule, and we threw some nieces and nephews in the trust as well, just so it could continue during their lifetime. But yeah, it is important to think about that, whether you're actually going to name that person or leave them money, maybe you decide not to, but it's worth thinking. And does that go on your power of attorney?
Right.
Because when older person becomes incapable and goes in care home, and dog has to go somewhere, but we need to pay for dog, can the attorney use mom's money to pay for the dog that's now owned by somebody else?
Again, lots of variables, right? So there's no clear-cut answer. Okay. You know what? We're actually on time, which is kind of incredible given that it's you and me who like to chat a lot. So we thought it would be kind of fun to have like a rapid fire, keep the answer to like 1 or 2 minutes kind of thing. So I've got these written down. These have come in from clients. What happens if I die without a will? How much of that goes to the government?
Question. So the government's written a will for all of us, the BC government. So it's provincial. So if you have assets in other jurisdictions, other rules may apply. But the government says if I die, goes to my spouse and kids. My spouse and kids. So it doesn't automatically all go to my spouse. Anything in my name gets divided, spouse and kids. Yeah. And then if I have no spouse and kids, parents, siblings, nieces, nephews, sort of climbs out the family tree. Some people don't like the will the government has written. So then obviously you need to have a will, and the kids inherit at 19, which I just said we shouldn't do. We only go as far as your cousins when we climb out the family tree. If you don't have any of the, parents, siblings, nieces, nephews, cousins, or your next of kin, we don't go to their kids. It goes to the government. So we used to have to find your relative, even if that was your third cousin twice removed back in the old country. We don't have to do that anymore. At some point, it goes to the government. And actually, others can apply to the government and say, I should get that money. And we've done a couple of those. So it's actually worked out all right. But it's better to just do a will and say where you want it to go.
Sure. Okay, thanks. Who looks after my kids if I die without a will?
Kids, meaning kids under 19. Once you're over 19, even if they're incapable, there's still no guardian for them. So you can't name a guardian for your 25-year-old, even if they're incapable. But anyone under 19, the superintendent of Child and Family Services, or whatever that ministry is now named, becomes guardian. And the public guardian and trustee becomes guardian of their assets. So if your sister or brother or mother or next door neighbor wants to be the guardian, they actually have to apply to court and prove that they're the best ones. And unfortunately, mom's family, dad's family tend to disagree,
Right.
which is why you need a will.
Right.
So yeah, the assets don't go to the government, but your kids do.
Okay. Okay. Can a person have more than one will?
Great question. Yes, and we do that all the time. So I might have a will here and a will in France where I own a condo, well, maybe. So you might have wills in different jurisdictions where you own assets, or in BC, if you're not yet 65 and you can't do that alter ego trust, and you've got maybe private company shares, I might do those in a will that put those in a will that doesn't get probated. So I can do a separate will for different assets. General will gets probated, restricted will for my company assets doesn't get probated. And no probate fees. Doesn't help on wills variation, but it can avoid probate fees. Mm-hmm. Some places it's called a probate will and a non-probate will. They've done them in Ontario for years. BC's just starting to do them. You need different executors, which makes it a little complicated. But yes, we do that.
Okay. Now, if you have moved from, let's say, Ontario to BC a year ago, but now you live in BC and then you pass away here, what happens if the only will you have is in Ontario?
It's probably fine. Our law says that if you did a will that was valid in the jurisdiction when you did it, it works. But we always, there's caveats on that, obviously. BC land, we take very seriously. Your will's got to comply. I'm sure it would be fine for all your bank accounts. We just have to make sure it worked for the land. Usually when someone moves here, I might do a double check of their will and say, oh yeah, this is fine here. What's more important is the power of attorney. They need a BC power of attorney to deal with BC assets. And we don't have powers of attorney for healthcare in BC. It's called a representation agreement. So the durable healthcare power of attorney from Ontario may not get recognized when you're in the hospital in Vancouver. So you would want to do a representation agreement for healthcare here.
Okay, so maybe
the will's probably fine.
Okay, so to summarize, I think you said there's a will, there's a power of attorney, and there's a representation agreement, and really should have all three of those things. And can you just sort of highlight what each one of those does, just one more time?
So will takes effect when you're dead, right? It applies to your assets after you're gone. Power of attorney is while you're alive, and it's financial, legal matters, contracts, running your business, those sorts of things. So just financial, not healthcare.
Okay. They
cross over a little bit with representation agreement is healthcare. So if, Ray, I'm your representative and I decide I think you need hip surgery and we're not going to wait for 2 years to get it. I'm going to send you to the Mayo Clinic. But the attorney says, I'm not paying $100,000 for Ray's new hip. You can have a conflict, right? Usually I draft it so the healthcare takes precedence, but they're two different documents dealing with different things.
And are they typically the same person or different people?
I would say probably half and half. We all have people in our life who are better with money, and sometimes it's other people who are better with people, right? So it's the same with parents of young kids. Might have a different guardian than the trustee holding the money.
Right.
Often that's a different person. And I think it's not a bad thing. There's a bit of a check and balance. I feel more comfortable. At least two people are looking at this decision.
Yeah. Okay, great. Someone says, I have certain things in my house that I want to go to certain people. Do I have to put that into my will, or can I leave a list somewhere?
Great question. Happens every day.
Yeah.
So if you want it to be legally binding, absolutely, for sure. And I'm going to suggest, and it's valuable enough that people would fight over it. And that's a bit of a caveat because kids will fight over anything, right? The dining room chairs, the silver spoon, it's emotional, and they all turn 12 years old sitting around the dining room table fighting, even though they're in their 60s. But if you want it to be binding, it goes in the will. But it means every time you change your mind, you have to do a new will. And it means every one of those people, those recipients, gets a copy of your will when you die. And if there's non-Canadians, it's going to get complicated. And we now, to transfer the real estate, I know it's unrelated, to transfer real estate, we have to list all of the beneficiaries, even of the silver spoon. And we need their SIN number. We need dates of birth. We need all kinds of information from the person who's just getting the spoon, the next door neighbor. So for most items, I recommend giving them to someone. You can't just leave a list, but you can say, I give all of my personal items to my daughter, Lauren. It's my hope she'll follow my wishes. Then I have my list, and those people are not beneficiaries. Lauren doesn't have to give it to them, but
right.
if she's going to follow my wishes, she doesn't want any of that stuff anyway. But you've got to be pretty sure of that. What you can't use, and I describe it as the yellow sticky method of estate distribution. You just can't put stickies behind the painting and under the chair and hope that that's all going to work out. It can be fine if everyone dies in the right order, but they don't always. And so my daughter's gone, and now there's minor kids, the grandkids are in the mix. They can't agree that the spoons go. So it's better to give them to someone and then have a list. You'll see people talk about a memorandum. You can do a memorandum, but it's got to be incorporated by reference. You may as well just type it in the will. It's just a word processing question at that point. So.
Okay. All right. Wow, we're covering off some good ones here. The question is MAID legal in BC?
Oh, good. So not to do with your will yet. This is the dying part.
Right.
So MAID is medical assistance in dying. It is legal in British Columbia. We've had probably most people on the line have actually heard of someone who died with MAID. That's where if I have excuse the wording out of the act, a grievous and irremediable medical condition, and it's causing enduring suffering that's intolerable. I have a horrible medical condition, enduring suffering, intolerable to me. I can ask a doctor to end my life. Right now, I have to have capacity to ask the doctor. So I've still got to have the wherewithal to ask the doctor for MAID and can end my life, and that's happening all the time. The question I get most often is, can my healthcare representative do that for me?
Right.
So if I know I've got Alzheimer's, I know within the next 8 years, I am going to be in a certain condition and I don't want to live like that. When I get to X point, Ray, as my representative, I want you to ask the doctor.
Yeah.
And put me down just like my dog, right?
Wow.
And that is not legal yet. There's some talk that they might bring in something like that. And I say most of my clients want me to put that in the representation agreement and say, if the law permits, I want my representative to be able to ask a physician for medical assistance in dying. So
it's in place now, but you have to have capacity.
Correct.
Okay. All
and
right.
Just so you understand why that's controversial, and most of us will remember that case on the prairies, Latimer, where the fellow had a very disabled daughter, and in the front of the truck, carbon monoxide, daughter dies. And, was that the right thing to do? And it was a huge issue. And so there's a concern if people can make decisions about the quality of life of other people, might they be putting them down too early?
Right.
So it is a hard decision, but I think the thinking is, if I trust you to make that decision and you know me and I put it in writing, should you be able to do that?
Okay. Next question. We're almost out of time here, but we're just another couple.
Okay, keep going.
Regarding wills, do Canadian citizen beneficiaries need to be resident in Canada?
I guess wills, I'm more concerned where your assets are that the will is supposed to cover.
Okay.
So you don't have to be, so if you're doing the will and you're a Canadian citizen elsewhere, you just need to make sure if your BC property is covered in a BC will, or if your will is valid in BC, but you did it in California, that's fine. When I mention citizens that aren't Canadian, that's if they're beneficiaries of trusts.
Yes.
That's where it gets complicated.
So,
or if they're trustees.
Yeah, so I think the question is, my child is in school in the US. They're a Canadian citizen, but they're attending school in the US. I pass away. What's the impact?
That's typically fine as long as they're not and it's fine even if they are a US citizen, if you're giving it to them outright. It's only a problem if you're leaving assets in trust. Where I worry about the kid going to school at Stanford is sometimes they meet someone else who's going to school in Stanford, at Stanford, and they enter into a relationship and they have babies, and maybe those babies are not Canadian citizens.
Sure.
And the spouse is not a Canadian citizen, and maybe by then the Stanford child is also a US citizen. So US citizens, even if you're also a Canadian citizen, but US citizens is an issue. But kid going to school on a student visa, no big deal.
And that's the same if through an alter ego trust? Or
say I think so, but I always check with a US advisor. The rules are really tricky. And I think with Biden, there's going to be some changes and who knows what those are. So I think we have to be careful.
Cool. And I'm going to go last question. And we're sticking under our 60 minutes, which is kind of impressive. Mother died in Alberta.
Yeah.
Can I challenge her will?
If mother's assets are in Alberta, no. Alberta has a different wills variation scheme. Okay. And you can only challenge the will if you're maybe if you're underage or if you're a dependent, but you don't have an automatic right to challenge mother's will. If mother has property here, that may be a different matter.
Okay, so it depends on, does it depend on where she died or just where her assets are?
Where she's resident, where she's, most closely connected, and where her assets are.
Okay. All right. So we're about 1 minute left here. So thank you, Mary, so much. I think you covered a huge number of topics, and hopefully that, triggered some questions for people. I think we dove in, a little bit. I know that every situation is going to be specific to each individual. And so on behalf of everybody listening today, and especially the Danielson Group team, thank you so much for taking the time out of your day. And I think it went over really well. So
I enjoy answering questions. It's all good. Thanks very much.
All right. Thank you.
Okay.
Bye, everyone.
Bye, all.